Hello, everyone. Harry here to talk about Judge Eileen Cannon's latest order, which takes us farther upriver in convoluted fashion to unexplored territory and just continues a sort of bizarre and time-consuming process for her to decide on what should be very straightforward legal motions that, moreover, all have been decided against Donald Trump already by multiple courts. All right. So we talked already about her setting a hearing for June 21st on his Trump's appointments clause challenge, which for, super federal courts jocks following along at home is not the standard kind of appointments clause challenge that says, this entrenches on the president's core Article 2 abilities in the first place. Rather, it's a much more nuanced and regulation-driven. It has to do with interpretation of the DOJ regulations that provide for a special counsel against the backdrop of Article 2, and basically concludes in an argument that really has gotten very little, has been roundly trashed, by within people who know this and by courts that have taken it up. But that Jack Smith, for purposes of the appointments clause, is an employee, not an officer. That has significance that I don't think we have to go into, but basically from that step, it leads them to conclude that the only way he could be appointed or anyone could be appointed is if they've already been confirmed by Congress. For example, a former U.S. attorney. It's a novel, you could say tortured, you could say very complicated, sort of tinkers to Everest to chance read of all the provisions of law, especially the regulation that was under Janet Reno that now controls for special counsels, which was adopted in the wake of perceived deficiencies with the independent counsel regime that we had before. But the thing it isn't, however convoluted it might be, it's a straightforward legal issue. And by convoluted, I just mean you have to kind of trace it through the sort of mousetrap as opposed to, a very simple constitutional analysis only. But it's not difficult or challenging, which makes it all the more perplexing. She's not only having the hearing, but having, as was, we talked about yesterday, 3 different amici get up for a half hour each in a motion to dismiss. Literally never heard of this. What is it exactly? Friend of the court is there to help the court. Like we see this in the Supreme Court when a certain organization really knows something in particular, say about in an abortion case, the position of doctors or of a certain class of patients, whatever. What here can't Trump do that she wants these 3 people, or the parties, because she's actually put one who is 2 for Trump and 1 on the other side. No idea. And then the actual kicker in the order she did, not only, so she says, we are going to do those 3 things and then accommodating any presentation of evidence if deemed necessary by the court. What evidence? This is a straightforward legal issue. What evidence does she have in mind? I mean, I'm sure Trump would love to put, people from DOJ on the stand, or Merrick Garland, to talk about the appointment of Jack Smith and how it happened, and to try to suggest communications with the White House, all of which have exactly nothing to do with the legal issue. So this is, Cannon at her pernicious, not best, not just in delays, but in confounding things, bringing in complete side issues. This is how we made her acquaintance in the first place, was in taking a simple Fourth Amendment issue and totally expanding it and bringing in the whole apparatus of a special master and claims of privilege, all these things that had no business then and basically no business either. So this is a little piece of this. What the hell is going on with three amici, and what the hell is going on with possible presentation of evidence? And none of it, let me say, augurs a shorter presentation or decision on her part. And that's, by the way, the other big theme here, since, she's setting hearings on motions and issues. Ain't that great? Well, no, they should have been done months ago, and there's just no indication of her, of when she's going to hold and issue opinions that, if they go for Trump, would give at least a basis for going up to the 11th Circuit and recusing her. All right. Then second, the appropriations clause challenge here, which is, I would say, even weaker. The idea is that the funding for the special counsel comes from a sort of it's not through the ordinary budget process, but a permanent, indefinite appropriation. That's what Reno did in order to insulate it more from politics. And they say in their motion, thus it violates the appropriations clause. That, hardly any. Well, that's the basic idea. Why does the appropriations clause require that it be done this way? Why does it prevent the good government solution of keeping Congress from being able to do what I'm sure Jim Jordan might love to do, which is to say, we're taking all your money away for special counsel for exactly this reason, so they not be able to do it. And I don't see the appropriations clause challenge. Nevertheless, after doing this potential multi-day hearing, she's going to hear the appropriations clause 3 days later. We'll hear argument June 24th. And then the next day, at least she's not providing for more than 1 day on June 24th, she's doing more or less what she should, this is the more orthodox approach to the whole search that she completely hijacked with her crazy process with the special master and the like, how we first met Judge Cannon. So they want there's the basic Fourth Amendment hearing, Fourth Amendment challenge that the search is unreasonable, but also, and importantly, they're moving our Trump for a so-called Franks hearing. They want to really impeach, or at least put on the stand, the agent who filled out the affidavit, press on the issues in the affidavit, press on a claim based on sheer speculation that somehow that process was politicized, again, involvement of Garland or the White House or all kinds of things, again, that are rank speculation. And here we have it. Should they have the particularity? Is the warrant particular enough? Fine. Does the exclusionary rule? Fine. But then, should a need arise for an evidentiary hearing on any of the foregoing topics, the court will schedule such a hearing in due course. So not even saying I might take evidence then, but rather I might decide evidence needs to be taken, and then we'll decide it in due course, maybe after what? Discovery, deposition. It's just, so this is the really 1-2 cannon whammy of both complication and convolutedness unnecessarily, combined with possible delay to do the evidentiary hearing, etc. And then, so that's, she's finally deciding some motions, not even the biggest ones, but it just with no indication of when, and every indication of additional delay. And then from there, she invites them basically to say, do you need any more additional material on we have also a ruling in the D.C. court, Beryl Howe, about the crime fraud exception materials involving Evan Corcoran. And the whole, there's evidence that comes in involving Corcoran for when, recall the subpoena was served and Trump basically says, ignore it. She wants to maybe redo that. And with, do you need any additional material? Defendant Trump. And then in light of that, the court hereby cancels, of course, why not, the partial evidentiary multi-day hearing on a motion to compel, and that has to do with bogus suggestions that the DOJ has abused or not the discovery process or not complied with their discovery obligations. So nothing in here about actually deciding things. Lots in here about a lot of process for things that are really simple, straightforward, and legal only. And then this real sort of smoke bomb about a whole process for the crime fraud exception, and wouldn't Trump love to have her reverse that and therefore not have the DOJ not be able to use all the information that's already been held to be a crime or very enough likelihood of a crime to use it involving Trump's obstruction of justice when the subpoena came in his communications with Corcoran, and it's also Nauta and Oliveira that basically have him red-handed in obstructing the subpoena, an actual issue that goes to the heart of things. No good news. I'm sorry, friends. All there's some action of sorts, but action that both complicates the case and augurs long delays to the case. We are, within a hair of saying, putting it in the same column that we put the Fulton County case in today of no worldly way that this actually is heard in 2024. She's given no indication of even a ruling that could be appealed, and she could be recused. And we're reaching a point where even if she were somehow, and obviously she's focused on not, another judge up to speed, et cetera, makes it all very remote. And then, of course, the 1-6 case in the Supreme Court immunity argument coming out, which may doom that one for 2024. So there you have it. As always, it's the ballot and not the courts that will be deciding accountability for Donald Trump. It looks, save only this verdict in the least grave, not to say not grave, but least grave New York case that was just proceeded to conviction last week. But down in Mar-a-Lago, it's its own kind of crazy land. Nothing quick, nothing clean, nothing old, because it's all idiosyncratic and process that people don't see normally, and nothing good coming from the chambers of Judge Eileen Cannon. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.